205.52. Well, they tell us here in A that sections 205.53 through 205.55 of this part shall be applicable to all agency and private placement adoption proceedings in family court. But we're not even in that one, so I don't know why that's on here. B, in any agency adoption, a petition may be filed to adopt a child who is the subject of a termination of parental rights proceeding and whose custody and guardianship has not yet been committed to an authorized agency, provided that 1. The adoption petition is filed in the same court where the termination of parental rights proceeding is pending. So that would be family court, because how are they going to terminate parental rights in surrogate's court? 2. The adoption petition, supporting documents, and the fact of their filing shall not be provided to the judge before whom the petition for termination of parental rights is pending until such time as fact-finding is concluded under that petition. And C. Where a child is under the jurisdiction of the family court as a result of placement in foster care pursuant to Article 10, Abuse and Neglect, 10A, I forgot what that was, or Section 358A of the Social Services Law, the adoption petition regarding the child shall be assigned wherever practicable to the family court judge who last presided over the child's child protective, foster care placement, permanency, surrender, or termination of parental rights proceedings. They just told us what all that was. 10, 10A, and 358A. That's what that whole list is talking about. Wherever the adoption petition has been filed regarding such a child, either before a different judge in a different court or before a court in a different county, the petitioner shall so indicate in the petition, and the petitioner's attorney shall file an affirmation by the attorney for the petitioner on a uniform form promulgated by the fucking chief administrator of the courts, attesting to the reasons for and circumstances regarding such filing. The court in which the adoption petition has been filed shall stay the proceeding for not more than 30 days in order to communicate with the family court judge who presided over the child's most recent child protective, foster care placement, permanency, termination of parental rights, or surrender proceeding, and afford the agency attorney and child's attorney in the respective proceeding an opportunity to be heard orally. I don't know what other way they could be heard. In person or by telephone or in writing. Oh, I guess those are the other ways they could be heard. Okay. Pursuant to Section 113 of the Domestic Relations Law, the family court judge who presided over the child's case shall determine whether the adoption petition should be transferred or should be heard in the court in which it has been filed, and shall record that determination on a uniform form promulgated by the fucking chief administrator. This determination shall be incorporated by the court in which the adoption petition has been filed into an order on a uniform form promulgated by the chief administrator, either retaining or transferring the petition. If the adoption petition is to be transferred, the transfer must take place forthwith, but in no event more than 35 days after the filing of the petition. So in this case, we have two time rules, 30 and 35. The court in which the adoption petition has been filed shall stay the proceeding for not more than 30 days. 30 days. In order to communicate with the family court judge of wherever that other stuff is. The 35 days, if the adoption petition is to be transferred, the transfer must take place forthwith, but in no event more than 35 days. Transfer forthwith, 35 days.